Good afternoon, evening, whenever you are. Hello, wherever you are. Hope everybody's well. Not legal advice. Please like, subscribe, comment, share, whatever else. Appreciate you all out here today. Saying hello to the ones I see. Hello, Mr. StreamYard. Hello, Gunner413, Renee, Lou. Moving over here. Gator Boy, Kerr, Market Watcher, Cheese McCracker. I like that one. WV, Frank Lee, Frankly. That's two different people. Hope everybody is well. So, and Barefoot just came in. Hope everybody is well. I wanted to update you on the GTI thing. Yesterday was a deposition of Frank Benendo. I wanted to kind of go over it because some interesting information came out and might be useful, or give you a status, some information about status. That is separate and apart from the transactional matter. I've seen some postings by Forster recently about the transaction side. This is not the transaction side. This is more the side about dealing with those disputed shares, and also I think dealing with any claims that have been submitted. And we'll talk about that a little bit when we get into this. Before we get started, I'm going to do my normal 4 up front, 2 on the back side. And hopefully you'll know what I'm talking about. Hopefully that wasn't obscene, actually. Hopefully. 4 up front, 2 in the back side. I come from a family full of police officers, except for my grandfather, who was a thief. He died last week surrounded by family. I have to turn the page now. I told, yesterday I started a new gym. So I went with my personal trainer. And after about, 10 or 15 minutes, I told him, wow, this exercise is really wearing me out. He replied that this was just a tour of the gym. A tour of the gym. If a robber robs a house that's being remodeled and leaves a print in wet cement, does that mean the police have concrete evidence? And last but not least, if I can find it, should I do that one? Oh, yeah, I'll do this one. There were 2 thieves. One had a speech impediment. The one without speech impediment, as they're robbing a bank, he picks up a bottle of whiskey and he turns to the other one and says, "Is this whiskey?" The other gentleman says, "This is not whiskey. It's robbing a bank." All right. So let's move on to the deposition. So a deposition is a testimony under oath, where your testimony is being, in this case, videotaped and transcribed by a court reporter, so typed up in a booklet form. What is that used for? It's used for to figure out what the other side's facts understanding are. Can be used at trial, could be used at other proceedings, could be used to impeach somebody's credibility, etc. In this particular case, the deposition is Frank Benendo, who was a former officer and director, and per him, also an independent contractor of GTII. I guess he's no longer, because after the receiver was put in place, everybody was banished to the desert. So in a deposition, the deposition started approximately 1 p.m. Eastern time and had a break midway and ended approximately 9:45 p.m. Eastern time, approximately. Just about, it's paragraph 40 of the order appointing the receiver gives the receiver a chance to investigate claims. So this was not about a claim that was being brought about Benendo. This was to investigate potential claims and about the disputed shares. So if in fact there's a future claim brought against Benendo, they could still depose him, and perhaps they could depose him if there's other claims, because this was a limited purposes. So right now, the receivership is hunting down assets, but they haven't like sued anybody yet. Part of the effort is to get the disputed shares back. After they get the disputed shares back, then the issue will be: do they want to proceed against the officers and directors, for example, for some type of breach of fiduciary duty? That would be separate and apart in getting the shares back. So like the shares back would be one thing, and then perhaps additional action would be for damage caused to the company. Now you have to evaluate whether those, whether defendants are collectible and when the time comes. But I wanted to distinguish between getting the shares back, and other assets, which is this stage, versus suing for damages, which we haven't got to. So before I kind of start describing what happened, the basic position that was offered by Frank Benendo, who was represented by counsel, and I'll tell you who was there, was the Animal House defense. So I was in college during the movie. I'm sure most of you have seen Animal House, the movie, when that came out, in a fraternity. So it was very well timed for me. And in Animal House, for those of you who don't remember, John Belushi was one of the stars, and he's consoling the character Kent Dorfman, who got in because his brother was formerly of that fraternity. And Belushi is trying to console Ken Dorfman after they destroyed Dorfman's brother's car. They went out on looking for women, and during that process, they destroyed Kent Dorfman's brother's car. And then Belushi, when they get back and the car is completely in shambles, Belushi turns towards Dorfman and in a very sympathetic tone states, "You effed up. You trusted us." And I think that's basically the defense that's offered by Benendo, that he put his trust in Reichman, and Reichman's responsible for everything. And we'll get into more detail and kind of how that plays out and why you would take that position. But we will get into detail. But that's basically his defense. I trusted Reichman. Reichman screwed everybody, bullied everybody. And, I wasn't there day to day and whatever. That was a summary of the defense. So at the deposition, the deposition occurred in Las Vegas. I had considered driving there, but since I could do it via Zoom, I did it via Zoom. So at the deposition itself were the court reporter, Dylan Siciliano, Frank Benendo, and from this point in time, it's going to refer to him as FB or Frank, and Mr. Whipple. I didn't get his first name, and I think he's the same guy from the Charmin commercial, if you guys know that. But he was there representing Frank. On Zoom were me, the receiver, and I believe Reichman's counsel, plus the court reporter. So I think about 7 people were involved. No one asked any questions other than the receiver, and maybe that was a choice. I think Mr. Whipple could have asked questions if he wanted, and Mr. Reichman's counsel could have, but I don't think it was a great environment for him to do that. So those 3, Dylan, Frank, and Whipple, are in a conference room with the court reporter. They're being videotaped, and the court reporter is taking down what is asked. Description of Frank Benendo: he's 78 years old. I thought he looked good. It tells you how old I am. I thought he looked good for his age, in my opinion. He had male pattern baldness, long grayish, whitish hair, was wearing glasses, was wearing kind of like a polo-ish shirt. And a deposition is questioning under oath, just to kind of put that in proper perspective. So he was there. I was kind of watching him before proceedings start. He was fidgeting a little bit because for most opponents, it's stressful to be in that environment. You're going to be questioned. You often get prepared prior to a deposition. What's supposed to happen is your counsel is supposed to go through it, because all that is confidential. You're meeting with counsel. and they're supposed to basically prep you with what could you expect to be asked. And you may not be told everything, but you're given enough information that you're able to extrapolate. But so before the deposition, I presume that Frank met with Mr. Whipple to discuss Charmin and other things. And Mr. Whipple would have kind of brought Frank up to date as to what's going to happen, how to, things to look for, whatever. Frank apparently had not been deposed previously, so this was his first deposition. As I said, and it was Dylan who actually used this specifically, it was the Nuremberg defense, just basically following orders. Throughout the course of the deposition, Frank constantly said, and I think he thought this was somehow protective, that he was not involved. And I kind of feel sorry for them before I go on. Notwithstanding whatever happened here, I kind of feel sorry for Frank. I know kind of like I've seen these situations before. People have friends, quote unquote. Their friends offer them some opportunity or situation. Perhaps they don't fully disclose, or perhaps they're scumbags, one or the other, and they get sucked in and they don't know how to get out, or they get lured in by money or offers of money or delusions of grandeur, all that. So I've seen this before, how someone who may not be a bad guy gets sucked in, and then the ramifications are dramatic, and that happens. So you have to be. Don't take anybody. I've said this before. Just another time, another reminder. Don't ever take anybody on just on face value. Make sure to do your own investigation. And it's oftentimes people get taken when they know the person and are close to the person, because that puts our guards down. So I think it's really important, and kind of like this is an example. I don't know if I didn't get the sense that Frank Benendo was a bad guy. He may have made some bad decisions and didn't seem like he carried out his functions as an officer and director, which I'll get into in a little bit. But I think he got duped. He said that the reason he got involved in GTII in the first place, and I think it was Treetop or whatever the prior name, was he was involved in some kind of business, I think marketing popcorn or something. I think he was talking about. I guess he was a very good popcorn marketer. And that business then struggled, and I guess he was introduced to David. David helped him. He became an officer and director and apparently independent contractor, and then stayed on. I don't know why he stayed on, but stayed on for some reason. So the way he portrayed it, he didn't even get involved for money. He got involved as like a favor for David. But if you get involved as an officer and director of a public company, you have an obligation to shareholders. This is not legal advice, by the way, of course, but you have a fiduciary duty to your shareholders. So even if you just do it for fun, that's not a great job to do for fun, because there's not a lot of upside. And he kept on throughout the hours and hours of question and answers. And my bill for 10,000 is on the way, by the way. He kept on saying that, he wasn't there day to day. Like that was somehow a defense. He really did not understand, at least my take, he did not understand that he actually had a duty to shareholders, and that being an officer and directors, you just can't just exist and screw up without doing a diligent job. You have an obligation. And he relied upon David. I think that's what he said repeatedly. So they would have these meetings where share issuance was discussed. And David, who Frank said, bullied everybody, especially Kathy Griffin. And I don't know why those people don't just get up and get out. At some point in time, they should just leave. But he basically said that David bullied everybody, and including Frank. Frank, he said he stood up to him, but should be noted that at those stock issuance, so what happened is there'd be a stock issuance. No, I think according to Frank, at any of these meetings, there was no like accountant or attorney that spoke. There was no written package that was provided per se. There was an agenda, but no like written backup. And the way it was described was, let's give 3 million shares to Justine because she she worked at the car wash. I'm exaggerating, of course, not true, but it was like that. Frank would then hear it. He would say whether he agreed or didn't agree. He never said no, and none of those board members ever said no. Frank said because David still had control. I guess he had 51% because he had preferred shares that he had jimmied up somehow or whatever, or they had agreed to give to him apparently. And so he justified it by saying that didn't make a difference what I said, he would still pass it. They made no justification for why he didn't resign based on that circumstance or why he would stay. But it'll make sense why he stayed, I think. He didn't say this, but I'm going to kind of interpret why he stayed. So he's involved in this. I know he got stuck in it, so I have some sympathy for him being stuck. But he just didn't do his testimony was, the way I interpreted his testimony was the concern is that these people have is for securities fraud. Could be civil, could be criminal, probably also RICO, because that was mentioned by the receiver that they had considered pursuing a RICO action on breach of fiduciary duty. I guess they haven't decided yet whether they're going to do that or not. But in the bigger picture, since we know the SEC sent out a subpoena to David, and since they're around, and we suspected they were around, then, and I'm just speculating here. So perhaps counsel for, and maybe I would make the same decision. So let's Frank, and I'm just making up the speculation. So Frank comes to me, explains the whole situation. I say, wow, you're screwed. Because, and I haven't gotten to the part where I know he's screwed, but my opinion, but his attorney might have said you're screwed. So we can't just deny it didn't happen. So let's just say you didn't know. And if you say you didn't know, then there's no intent, no malice, and it can't get you for securities fraud. It can't get you for anything criminal. And even if you're, technically didn't do your job, perhaps there's other pockets they can go after, and and you escape. Doesn't cost you too much, whatever. And that's the position. So that's what it appeared to me that there was discussed, the strategy, because he kept on repeating he wasn't there day to day, he wasn't in control day to day, thinking that somehow just like mere being incompetent or not doing your job as an officer and director completely protected him. And I don't know who explained that to him. If his counsel explained that somehow protected him from liability, period, then I think that's just not appropriate advice. But I don't know. I really don't know. I thought his attorney, by the way, Mr. Whipple, I thought he was way, I haven't got to that point yet. I thought he was way too quiet. His client was sweating, and there were certain times during the deposition I could see he became uncomfortable, specifically uncomfortable, and I'll address it. And I thought his counsel was way too passive. He, because Dylan Siciliano was taking the deposition. He was doing it in a very conversational way that it was flowing very easily. When that happens, then you elicit a lot of testimony from the witness, and that's what you want. You want the witness to speak and to create a record and to say things. And his attorney was sitting there like I don't know, like a stump. He wasn't interjecting objections. He did some. Let's say maybe during the time I said, he maybe asserted a dozen objections, no instructions not to answer, just not enough interference in the process. So the flow inured to the benefit of Dylan. I thought my evaluation on that. I was kind of surprised that his counsel was that passive, because I didn't think it was a service to Benendo, but not my client. So that's just my observation. One thing that he raised early on was that he had contact. Oh, a couple of things. So a couple other people came up as like involved with GTII. A gentleman named Sal and Tommy Wang came up both. Not very much about Tommy Wang. Just mentioned that he had some. I guess he was involved in some transaction. As to Sal, who I've never met, apparently he provided services for GTII at some point in time and got a bunch of shares. But Frank Benendo really had, he didn't say it specifically, but he had negative things to say about him. I guess he had a couple terms with GTII, and I think Benendo didn't want him there the second time. Had a bunch of negative stuff to say about him. There weren't a lot of names, kind of like extraneous names that were mentioned. Those two were mentioned, and Tommy is, I would say, neutral, and Sal, I would say, slightly in a negative. But I don't know. I haven't had any involvement with him, so I don't really know. Other than the fact apparently he was involved with GTII at some point in time, provided deals or stuff, which Benendo agreed that he did provide stuff, but he didn't really explain why he had negative feelings about. Benendo didn't explain why he had negative feelings about Sal, but I don't know. One thing that he mentioned, Benendo, is that David Reichman, who remember is a tax expert, and we ended up with Borgers and all the audit issues, whatever, but he was a tax expert, right? And this kind of will serve you right, I think. So Benendo had Reichman do his personal taxes. As a result of Reichman doing Benentendo's personal taxes, Benendo was audited by the IRS in both 2021 and 2022. So shouldn't he have known back then? Because he was involved with Reichman at GTII and its predecessor since 2006. Now, I don't know what he did, honestly, because I'm going to get into that in a second. But that's a long time to be involved with. So one thing he claimed at the very start of the deposition was that he had brain fog, and it was age-related. And it was, I think he said, and again, I don't have a record, so these are notes, so this may not be 100% accurate, but it's certainly ballpark, that at least for the last couple of years, he's noticed that, and he kind of left that as a preface. He left that as a preface to kind of give himself, I think, to give himself an out if his testimony changed or was not believable or whatever as to any detail. But what was kind of interesting is then he talked about he had recently filed a claim. So if you recall, the receiver has a claims process, and the claims process, so if you have a claim against GTII, you can submit the claim, and then the receiver will rule on it and will move forward. So this gentleman submitted a claim, and I'll get into it. Recently, so I don't know how a guy who claims he has brain fog can submit a claim and attest to the accuracy of a claim for things that happened many years prior to his brain fog. Makes no sense, honestly. I mean, if I were opposing the claim, that would be the first thing I would do is I'd take out the deposition and I would go to page 9, line 7. Witness says he has brain fog, which has increased over the past 2 years. So how could he be attesting to any claim that happened 20 years ago? Really makes no sense. Same issue would be as to the declarations. He submitted a bunch of declarations. He's saying he has brain fog. So what's the accuracy and legitimacy of a bunch of declarations that he submits claiming he has brain fog? I don't know. I really think it kind of hurts his credibility beyond what he testified to. If he doesn't remember, he doesn't remember, but you can't say you don't remember and then do a bunch of things that you have to testify you remember and asserting under penalty of perjury. Concerns me, just to be honest. When I heard it, he had contact and has had contact with both Kathy Griffin and Luke Rabari, and I'll mention those two in a second. It also came out during the deposition because apparently Benendo refused to an interview, that the receiver has interviewed a lot of people, including Kathy Griffin, Justine Reichman, perhaps David Reichman. I wasn't sure if that was. Then a bunch of people associated with issuers or people who have received shares. So there's been a bunch of interviews other than Benendo. I don't know if there was a question why he didn't submit to an interview, but he did not. So, and probably that would have been he might have avoided the deposition if he had submitted to an interview, and the testimony wouldn't have been any different, and it wouldn't have been public. So I don't understand why you would do this. Again, my judgment of his representation, I guess. Why would you not do this in private so it's not in a public record? But anyway, he chose it that way, whatever. So the receiver had interviewed a bunch of people, and that's ongoing, I guess. And but Benendo refused. So in about the first 15 minutes of the deposition, my YouTube channel came up. I think the question was asked to Benendo, something along the lines of, have you seen Mr. Hoffman? Yeah, Mr. Siciliano would not say Hoffman. He would say Mr. Hoffman. Mr. Hoffman's YouTube channel. Have you watched it? Benendo said that he'd watched the last one or two. He was aware of the channel, and then he said that Luke Rabari had called him or communicated with him and told him that I had disclosed that Benentendo's deposition was going forward. So it suggested to me that either Rabari or his office was monitoring my my YouTube channel, because he did, and told Benendo about it. So I don't know how many of the crew involved or formerly involved with GTII are watching this today, but if you're watching it, please like and subscribe and share. And I thank you for your participation. What also came up during that discussion, and so let's say over the course of the entirety of the deposition, at different instances. So I just gave you an instance where the YouTube channel came up. Had to be about 6 or 7 times where either I or the YouTube channel came up separate and apart from that during the course of events. So I'm sure at this point in time that they were aware and disturbed by that I was disclosing information about what they were doing. To the extent that at some point in time, there was testimony during the deposition that I think Reichman, Griffin, and Benendo were communicating with a white-collar attorney, so one who does white-collar, like this kind of stuff, or criminal defense. And I came up, and they were trying to I think, shut me down from criticizing the board. Thereafter, with that intention, they filed that defamation action, which was later dismissed. But after hearing Benendo, it sounds like I was suspecting, and I clearly appeared to me that it was based upon malice, their lawsuit against me. But after Benentendo's testimony, it appeared that he was confirming that it was based upon an improper purpose and malice. And to the extent that anybody comes after me, I will use that information and sue them for malicious prosecution. So we're just putting that out there. The only reason why I say that was during the course of the deposition, Benendo kept on repeating that Rabari, and he used different words, hates my guts, despises me, and wanted to sue me. And he's the reason they sued me. And so if that happens again, whoever comes after me is going to get, and I could have done it the first time, I elected not to, but now there's direct evidence of it from Benentendo's deposition, in my opinion, and I'm not going to wait a second to go after them or to force them to post a bond based on being a vexatious litigant. That's somebody who sues too much. Now, what was interesting also So they clearly they wanted to shut me down. That was another time with another attorney, and then they sued, and then they got shut down. But what was interesting to me was the description of Luke Rabari, and it was different. And I think, I have to give him props. I'm going to give props to Mr. Rabari here and put things in perspective based upon what Benendo testified to. So if you recall, Rabari came in as a consultant, and then I think became COO and then CEO, and then the receiver came over and he was gone. And during his tenure, there were a bunch of shares that were canceled. And the way that Benendo testified, Rabari's brought in as a consultant. He sees all the shenanigans going on. He is troubled by the issuance of shares that don't have a direct benefit on GTII, including that like January distribution of like 65 million shares. He sets up a committee. The committee is going to, and I don't know, David Reichman's not, as far as described by Benendo, is not a part of this committee. It was led apparently by Benendo, and they're supposed to go check out the issuances of shares that were questionable or should be questioned. He prepares a short list, Benendo, but by the time, and they don't take any action on it. By the time time moves on, receivers in, they do nothing. But Benendo multiple times says that once Rabari pointed out that there was a problem, he took immediate action, being Benendo. This might have been like in 24, way after the fact. And this is after he would have already approved the issuance of shares. So he approves the issuance of shares. Rabari then comes in and gives a different view of the issuance of shares, questioning a lot of the transactions, apparently. And then the same shares that Benendo had signed off on as a officer and director, he then questions them. And somehow that's supposed to be absolve Benendo of responsibility. Now, based upon what Benendo says, I understand the position of Rabari better. So he's coming in. He finds out that this is a shit fest, honestly. And what he does is he tries to clean it up. And while he's trying to cleaning it up, and I'm trying to find out information from GTII, I'm doing these live streams and videos where I'm absolutely crushing GTII management. And I'm sure from Rabari's perspective, I was his foil because I was making his job much more difficult because everybody was trying to keep things kind of on the QT. Now that I know he was trying to make things right, or apparently trying to reconcile things, didn't seem like he was the biggest problem here. It looked like he was trying to rectify the problem, but was stuck with it and was stuck with Reichman. I don't appreciate the lawsuit. I guess his concern was somehow that could damage his reputation. I don't see how that's the case. It is what it is. He had that position with the company, and the company stands for itself. And I don't think I accused him of anything specifically, but whatever I stated, certainly as to the company, was obviously proven up by more than I suggested. But anyway, I understand why Rabari would have been annoyed, because I was making his job much more difficult and keeping things discreet, making them much more difficult. But it appeared like he was trying to make things right, but there was no, it was not possible based upon the circumstances and based upon what was going on. So that was interesting through the deposition. And again, that's what Benendo testified to in the deposition, or at least part of it. Benendo was asked a lot about stock issuances, and we've talked about it. Justine gets 3 million here, and David gets X million here, and Benendo got, I think, at the end of 2022, 3 million shares worth $1.50, over $5 million, one shot. Then he got some more. At some point in time, it looked like he had about 8 million, but he's now left with like 5.3 million that are restricted shares. Think about this. Think about this. And this is kind of another reason why I have a little sympathy for him. I don't have a lot of sympathy, but I have some sympathy for him for his position. He has 5.3 million shares that he can't sell, that are restricted. And whereas other insiders got attorneys to write opinion letters to unrestrict their shares to be able to sell them, he did not. Now, I don't know whether it sounded like he was told not to sell the shares, or that they were restricted, or not given any information to know that he could get them unrestricted. But as of today, the way he testified, he has 5.3 million, approximately 5.3 million shares that are still restricted, that he hasn't sold, and he's not made a dime. And he's now involved in litigation. So look at the pile of crap that David left for Benendo, along with everyone else. Because Benendo was clear that Reichman was running the show, and he was bullying everybody, especially Kathy Griffin, as I mentioned before. So we talked about a lot of the stock issuances. So all these issuances happen over the years. And the question is, what did you do to validate this before you okayed them on all these board resolutions? And what Benendo said, time after time after time after time, I listened to David, and if he said there was some services provided, then I just signed off. Even if I think he even said, I don't remember precisely, so don't quote me on this one, that even if he had doubts, he never said no anyway. So, and he never, there was no written packet, there was no hire an investigator, go check, look at invoices, nothing like that. There was an oral representation that was sufficient. That happened time after time after time when the company is not making a dime, zero. How could somebody be operating in good faith with diligence when millions of shares are being sent out to various people? He doesn't know if they provided any services, and the company's not making I don't mean profiting. There's no revenue. He even referenced there was all kinds of deals that came in. It didn't happen. Some he thought, maybe they should have. He referenced one where he thought maybe some income, one where he thought some revenue may have come in, but there was no issue of profit, and there was no reference to how much. Could have been $1.50. But other than that, nothing came in. At the same time, they're issuing millions and millions of shares, and he doesn't say squawk, doesn't say no, doesn't resign, never resigned. And up until the time Rabari came in about the issuance and raised it, he basically was on the sideline. He kind of took credit for the fact that once Rabari came in and pointed it out, he was on top of it. And he created this, and it was on a committee, and created this list that nothing happened with. So pretty amazing. I don't think that's carrying out your fiduciary responsibility. I don't think that's doing a proper investigation. But again, these guys might believe that just incompetence is a sufficient defense because it keeps them out of jail and keeps them out of any kind of fraud action. But I'm just speculating about that, why you would do that and acknowledge, incompetence, neglect, and wouldn't try to fight that. But that's kind of the position they did. He kept on saying, I wasn't there day to day, and he thought that somehow absolved him of responsibility for having responsibility as an officer and director of the company. He also indicated, not only did he not say no, but every time they had those issuances, everybody else said yes to. So there was nobody. Everybody was in essence a patsy on that board. Everybody was controlled by David Reichman. Everybody was bullied by Reichman, according to Benendo. And who suffered? The shareholders. Reichman apparently used to complain all the time. We got no money. Probably had no money because where were the shares going? How were they being, what was he living off of? Apparently he got a condo based upon, that's what was said during the deposition. Apparently he got a condo based upon, his sale of shares. Him being Reichman, by the way, not Benendo. Because again, I don't know how Benendo financially benefits at this. I think it just was a poor decision. And again, I have my own speculation. I think He has those shares, 5.3 million. I think he's still hoping he can cash those out. I think he's still hoping it's going to work out. I think he's hoping he can still keep those shares, but we'll get that in a second. Told you that. Yeah. So those shares he got at the end of 2022 worth $5 million at the time. He gave an evaluation what he did for GTII. Apparently, his expertise prior was in marketing, even though, again, I think he testified he met David because his company was having problems. Marketing and some type of technical, even though he was not a tech whiz, and even though there might have been other people, but he was a facilitator, a creative facilitator, he said, and a marketer. Now, I don't know what he marketed, because what did GTII do that required marketing? And from 2006 through 2022, 16 years, 5 million, that means he's getting paid 300,000 a year at GTII, or the equivalent, for doing his marketing and his technical stuff, which seemed like, because it was impossible to understand what he did, maybe because of his brain fog or maybe because of other reasons, but it sounded like, maybe he would, on the website, he might be responsible for the font, or if an email had to be posted and Kathy Griffin generated some type of press release, it would be sent to him, and then he would provide it to somebody else, and they would post it. Maybe he was involved in setting up the voicemail. But literally, as far as I could tell, other than that, that's what he did. So does that justify getting paid? Apparently, and he got paid additional shares. And again, he said he didn't get paid for being an officer and director. This is just for being, I guess, an independent contractor providing these services, which weren't different than the services he would provide as an officer and director, which he didn't define, but $300,000 a year equivalent on a company that had zero revenue, that had nothing. And supposedly that makes sense. Somehow that makes sense. If you recall, the end of after Rabari came in, it sounds like at his direction, there was 35 million shares that were canceled, including some that were going to Benendo. And I think the conclusion was that that distribution wasn't for the benefit of GTII. Now, in the document that was submitted, the filing, it says it was an error. Benendo said that's false. So apparently the securities filing that they made was false. I guess that's securities fraud. I'm not a securities lawyer, but I think if you file like a false, this sounds like logical. If you file a false securities filing, that's probably securities fraud. And if you claim it was an error and it's not an error, you're putting error, then perhaps that's securities fraud. And I don't know who's responsible for that, but anybody who was responsible for the communications of the company probably should be aware of that and should have taken action on that. So let me continue on as I'm kind of recapping, like, generally what happened. My position would be, at some point in time, if he questioned the distribution of shares and he knew that Reichman controlled the board anyway, then the only logical thing would be to resign. That's the only thing. And not resigning keeps you exposed. And I don't understand. He never gave a good reason why he didn't resign. He felt an allegiance to, I think it's something along the lines, because David had helped him out. He didn't feel like he should resign. Nobody else was standing up to David. It really made no sense. The only thing that makes sense is Benendo thought that he was going to get a payday at some point in time because he still has the 5.3 million shares. And apparently it came out during the deposition that the receiver was considering and is considering, again, and I mentioned a RICO, breach of fiduciary duty claims. Didn't seem like, Benendo understood the duty part. He thought, again, that he wasn't day-to-day and as such that he's a free man. The proof of claim. So just imagine the balls. Just imagine the giant balls that Benendo has. So I'm sympathetic. So he filed a proof of claim. So, remember I mentioned that the receiver set up a system that if anybody has a claim against GTII, they could file it. And apparently there are a bunch of claims that have been filed. We don't know yet because the receiver hasn't disclosed them. There's going to be a date certain where all the claims are disclosed, and then the receiver is going to rule on them. And there may be a lot of defenses. The claims may be invalid for various reasons. Maybe a statute of limitations is run, or a lot of other reasons, because maybe they're bullshit claims also. But this gentleman, who has 5.3 million shares, filed a claim. Now, he did indicate that if he keeps his 5.3 million shares for all that work he did, that I just mentioned, that he couldn't really describe, and which obviously wouldn't equate to the number I mentioned in a company that's a piece of dog shit. But he says that if he keeps the shares, he'll forego his claim. And he claims that even though there's no written independent contract agreement, I think oral independent contract agreement, there is, I think, a few invoices, which I haven't seen, but of minor amounts, apparently. But he apparently contracted for work in 2006 and whenever for marketing and communications. Now, he never pursued collection of that, but what he did at some point in time, apparently, is he got shares much later on. And he's trying to retain those shares, saying that he provided these really ambiguously described services to GTII. Now, of course, the numbers don't make any sense, nor was he able to really describe anything of significance that he was able to do. And I think other people have also indicated they did, communications or PowerPoints or whatever. But it's incredible the amount that he was paid, because again, just that one 3.3 million amount, because he claims he didn't receive any for being an officer director, was equivalent to $5 million. Now, of course, there was one apparent document that indicated that he got paid $500,000 for being an officer and director, but he maintains he wasn't. And throughout the documents, including, I think, one agreement, the agreement putting, I think it was testified, the CEO agreement for Luke Rabari, and I don't know who backdated it. I think the allegation was Kathy Griffin, but I don't know. Somebody backdated it apparently, but there was a whole bunch of other documents that were backdated, and Benendo had no excuse for that, no reason, no justification. Again, just, I don't know. If you watch Hogan's Heroes, Sergeant Schultz, I see nothing, I hear nothing. Basically, you play dumb, and that's your defense. And that's repeated over that course of that day. That was repeated over and over and over again. So he got 5.3 million shares, Benendo, and he submitted a claim. His claim is for $859,040.60. That's probably enough to make you take a crap. And again, he said that despite the fact he has those other shares, but he did say that if he gets the shares, he won't go after the $859,000 apparently for doing whatever he did for marketing and communications, whatever that means. Again, no written independent contract agreement, and he says he wasn't compensated for being a director and officer, and apparently there was a document that said he got 500,000 shares. Whatever. He tried to explain what he did on the website. Apparently did some aesthetic thing, but it made no sense. It made like somebody describing something that they really didn't have an understanding of what they did, but that's what he said. But he said he was very well respected in his industry, and his reputation was important. I thought, this decision to go after the money or try to keep the shares is ill-advised. You've testified that you disregarded your duty to the shareholders. Not only did you disregard it, you didn't even know you had a duty to the shareholders. Even worse. And that makes no sense. Plus, this is from 2006, so your statute of limitations is blown. It doesn't make any sense to me why you would pursue a claim. You think how do you think the judge is going to feel based upon you signing off on all those issuances and then you're coming in for money? How do you think they would feel? There was discussion about because he was asked about, like I said, issuances, and one was to David Reichman's apparent fiance at one point in time and her Italian son. Apparently, he gave 12 and a, this is Reichman, gave 12.5 million shares as a gift to the fiance and son. And then there was some immigrant. This is what the questioning was and what the testimony was. There was apparently some type of, what the receiver's counsel said, immigration scheme that was set up. There was references to Dot A, Justine's company, and 3 million shares here and 3 million shares there. And what did you do? And he has no idea. He didn't check. He didn't go beyond what he was told. And again, he thinks that's an appropriate defense because David said it was all good. Now, there was one section where I thought he almost passed out. I think I mentioned earlier, and clearly the color left his face. And that's when he realized that he may have personal tax liability. He turned white as a ghost because basically all these shares, there was no 1099 sent out to anybody. There's millions of dollars in value that was sent out. No 1099s. So everybody who receives shares has potential liability. I'm not an IRS agent, but to the extent the company's responsibility, the officers and directors would have, because they would be deemed or could be deemed responsible parties, they could have personal liability for the tax liability that arises. When he heard that, I think he almost collapsed. That really threw him for a loop. I was watching him. It took him a while to regain his faculties. It was obvious. He didn't think about that. He wasn't aware of that. And he didn't believe that, I think underlying, he just didn't believe that Reichman would screw him. And, it looks like, according to the deposition testimony, that he thinks that Reichman left him high and dry. In 20, I said he wasn't there day to day, but when Reichman took a medical leave, he had some kind of a brain issue, I think, a brain issue other than normal, he took medical leave, and Benendo took over. And at some point in time, apparently he was vice chairman. Now, one thing that really annoyed me, amongst other things, was just prior to the appointment of the receiver, apparently, these guys thought about and attempted to or were considering filing bankruptcy, GTII. Luckily, we got in fast enough, and I knew that was a risk that these guys would try to, hide in a bankruptcy. But luckily enough, we got in soon enough to block that from occurring. And if, the receivership should end in a proper way, not in a bankruptcy, right? Isn't that the way it should end? There were discussions about, I mentioned this before, there were discussions about like all the deals that GTII had pursued or not pursued over the time. I think there was some reference to the audit. The audit wasn't done because of a delisting. I think that was what Benendo testified to, that there was a justification provided for no audit, because because of the downlisting. Didn't make a lot of sense, because it wasn't like Benendo scrutinized any of this stuff until, he says, after Rabari came in and pointed this out, then he started to scrutinize. But prior to that, based on his testimony, took everything at face value, notwithstanding whatever the circumstances were of the company, no revenue, no nothing, no business, whatever. But that's the testimony. So he talked a little bit about again, I mentioned this Sal. So the two people bringing deals, Sal apparently brought a bunch of deals, but none of them worked out. And again, he didn't have a very positive view of Sal. Wasn't clear why. The Receivers Council made reference to prior history, but it wasn't really clear. It seemed like Benedetto was aware of it. But anyway, it just kind of came up, it seemed like out of place. That's why it kind of stuck in my mind. He claimed that before Rabari came in, that he wasn't aware of the self-dealing and the shenanigans, and that this is referring to Benedetto. He learned a lot about it during the litigation. There was an attorney, apparently, Michael Brook, B-R-U-K, who apparently resigned at some point in time from GTII due to the insider actions. And apparently they've already interviewed Michael Brook also. When they had these presentations where they were discussing share issuances, Benedetto indicated that there was never an attorney or accountant who gave a presentation at the end of these board meetings. So, and there wasn't like packages, like you get paperwork beforehand that would describe the transaction. There was usually an agenda, like a written agenda, but sometimes there weren't even those. They kind of popped up. I think he said some of his meetings were quick, but there was no like professionals who gave an opinion about whether the transaction was appropriate or not. Now there was, there's prior testimony about some of the professionals were involved apparently in the wrongdoing or got benefits from transactions that you might say were questionable. But at none of these board meetings, apparently there was no professionals who were describing what the transaction was, and they would rely upon just some oral brief, do this, issue the shares, okay, without any pushback. I mentioned about the suspicious issuance of the shares, and I mentioned there was a bunch of backdating of documents, and that apparently Frank didn't really pay attention until after Rabari came in, and maybe Rabari mentioned the fiduciary duty. I don't know what else got Benintendo's interest up. Obviously, being sued or his name appearing in the receivership, that obviously caught his attention, and he never mentioned that. Indicated he never mentioned nobody did, and that he accused David of bullying everybody and pushing and being responsible. There was, issues about various trusts that got large in numbers of shares, Hans and Rosie Epstein Trust, etc. And he just didn't indicate any reason, any kind of investigation he did to justify giving any of those shares to any of those companies. He just accepted it without scrutiny. He wasn't aware of the fact that apparently that Reichman was using Arthur Schwartz credit card after Arthur Schwartz was dead. He didn't know about that, apparently. There was also reference to, before the lawsuit was filed, it seemed like there was a strategic effort to make sure that the plaintiffs couldn't get 10% of the shares to file a receivership action. And he was very kind of hazy about what that was, but he was clear that there was some attempt so that when the initial action was taken, that they could argue that there wasn't 10% ownership. And it might have involved the there was some AID deal with 20 million shares, and they tried to get it below, but there were other sections that permitted a receivership, but they were kind of like focused only on that. So I think that's the general gist of the deposition. He blamed it entirely on Reichman. He accepted whatever was said orally without doing any due diligence, in my opinion. He didn't really realize he had a duty. He only seemed to get interested once Rabari was brought in. He was on a committee, put a list together, but no action was taken about those shares. He still has 5.3 million shares and thinks somehow he's entitled to them, along with a claim for approximately $850,000 for services that he really couldn't explain, at least that I didn't understand, or I couldn't explain how they would have any value, any significant value in a company that produced zero revenue. So in the end, I thought, after hearing the deposition, If I were David Reichman, I would be concerned because everything's been brushed off in my direction. I've been accused of being a bully and of running everything and of making all these decisions. And then, of course, for the other officers and directors, if they did the same amount of scrutiny of these transactions, they're in the same position in terms of breaching their fiduciary duty. They didn't do what they were supposed to do, whether they got paid or not. And if they didn't want to be in that position, they should have resigned. That was the appropriate decision, which they elected not to do. And since they didn't do it, they're responsible. And there's no other way to looking about it. And, if I were Benedetto or Griffin or whoever else, as opposed to pissing away all my money in legal fees, which that's what you're going to do, because it's going to go, listen, if Reichman's been already subpoenaed by the SEC, my guess is that there are going to be others in that management who will also, if they haven't already received it. And you could piss away your money in legal fees, or you can come forward, contact the receiver or me, and cut a deal and get out of here and return your shares and quit this nonsense. And however you try to rationalize what you did a bad job and you neglected shareholders. And I'm referring now to Benedetto based on his deposition. I don't think you're a bad guy. I didn't think you were a bad guy based on your deposition, but you fell down on the job. You didn't do your job. Because you didn't do your job, this is where we are today, including you. You should have resigned when you could have. I know you're trying to wait for your payday. I know you think you're going to get rich off of this. I understand that. But the flip side is this is the ramifications. And your claim supported with your brain fog on where the statute of limitations, I think you should rescind that claim today. That would be a smart move and cut a deal. Just my opinion. Anyway, let's finish off with two jokes. So that's the summary of the deposition, at least for today. I'm going to finish off with two funnies, hopefully. What were my two funnies? First, it's a little off base, but what's the difference between a robber and a peeping Tom? I don't know. What's the difference? A robber snatches watches, and I'll let you fill in the rest. And last but not least, a robber holds up a well-dressed man at gunpoint and he demands, "Give me all your money." The man in this really nice suit replies, "Don't you know who I am? I'm a congressman." The robber then responds, "Then give me back all my money." Anyway, to all you out there, thanks for hanging out. I hope that was informative. I think it certainly dug the grave, in my view, dug the grave of Benendo in terms of his liability, of his right to receive compensation, of his claim, of his being supervising, of him carrying out or not carrying out his duties as a officer and director. He shed light on Reichman bullying everybody. He shed light on what Luke Rabari was trying to accomplish, which put it in a different perspective in that he was trying to do a job of, I guess, rectifying stuff that he recognized that was, and I'm speculating because I wasn't there, but it looked like he was trying to take care of problems that he saw. And then all these guys suddenly became very brave, like Benendo suddenly becomes Mr. Policeman, questioning transactions that he had approved. How could you possibly have a defense for that you approve a transaction and later, because somebody points out that you're a rube, then you oppose the transaction? That was supposed to be you, not somebody else. Anyway, just another day in paradise. Think for the bad guys, that wasn't a really good day. And I don't understand why they don't try to cut a deal. I mean, I just see the ramifications. Again, we know where Reichman's going to go. We know where this is headed. They're all headed in the same place. They should bail. I told them they should bail like a year and a half ago. I literally said, turn on this guy and come forward and save yourself. I think I did videos on that. I literally invited them to whistleblow on Reichman and save themselves. And instead, they elected not to. They're going to piss away all their money. They're going to lose. This is my view. They're going to piss away all their money. They're going to lose their stock because they were thick-headed and because they believed David Reichman. That's just my opinion. Anyway, to all you out there, thanks for being here. We'll keep you apprised, obviously. And as we find out more information about the transaction itself, I will let you know. I did send off an email to the Receivers Council today, and we've been in better communication. I'll say that. I did send out an email to the Receivers Council today saying after what Benendo said clearly shows that the lawsuit that was brought against me was based upon an improper purpose, a bad motive, which sets up a claim of malicious prosecution for anybody who proceeded that way or has any idea of proceeding that way. So anyway, leave it that there. Thanks for all hanging out here. Have a great day. Be well. Take care of yourselves, and see you soon.